Hi, welcome to my channel and please don't forget to like, comment and subscribe. Today I bring a topic about maritime rating, international law and the suppression of piracy on the South China coast on 1842 until 1849. The boats here resemble the fishes of the sea. The large are always ready to prey upon the small, and the small upon the smaller when the temptation offers. Such, according to Thomas Cochrane, Commander-in-Chief of the Royal Navy's China Station, was the Hobbesian state of nature which passed for a maritime order in the China Seas in 1840s. The pirates are creation of international legal ordering. Samuel Coleridge once quipped that no man is a pirate unless his contemporaries agree to call him so, because pirates operate on the high seas, which are not subject to the jurisdiction of a single state. Defining and suppressing piracy requires at a minimum communication and an agreed set of protocols between states. This will ask how such a set of protocols came to be established in the China Seas between 1842 and 1869. That this can tell us about the development of international law more broadly in China. This initially appears to be a case of the spread of legal norms from Europe through positivist international law-making as British officials wrote requirements. Also, it is for the king state to deal with piracy, as defined by Britain into the treaty which concluded the Second Opium or Aral War. In reality, however, the agreement to suppress piracy was haphazardly forged and rested far more on the transformative changes in the Qing state in these years. This reordering of the China Seas also involved defining the role of Britain's new colony, Hong Kong, making the question of piracy as much one of imperial as of international order. 1842 marked a turning point in Sino-foreign relation. The Treaty of Nanjing, which concluded the Opium War, ended the Canton systems, which restricted trade to one port on the China coast. Not only were 4 additional ports Shanghai, Ningbo, Xiamen, and Huzhou. It's opened to foreign trade, but the islands of Hong Kong was ceded to Britain. This created a British state interest in managing piracy on the China coast to protect British colonial waters. The opening of 4 additional ports did not, however, lead to a 5-fold increase in foreign trade with China, but instead led to the wider geographic dispersal of existing trade. This created jobs in the new ports but resulted in wide-scale unemployment among boatmen in Canton. Faced with these conditions, many disposed sailors took up raids on local shipping and were quickly defined as pirates by British observers. The apparent value of King officials to share this view or to act against them provoked British ire and led to debates about how to deal with the piracy problem in seas, where sovereignty was divided between the Qing state and the colony of Hong Kong. This study concludes in 1869 when a Qing foreign framework was enacted, which would lead to a dramatic reduction in piracy as it facilitated a structured collaborative approach. Many studies of 19th century British piracy suppression campaigns have emphasized the extent to which putting down piracy acted as cover for expanding British political influence. British maneuvers against piracy in the Persian Gulf from 1807 to 1820 have been seen as a political struggle against Wahhabi rule in Ras Al Khaimah. The fact that the Trucial States, now the United Arab Emirates, were made a British protectorate in 1820 immediately after the final skirmish against Qasimi pirates suggests this was a conflict with a land-based regime. Similarly, it has been pointed out that British influence in the Malay archipelago increased dramatically after 1820, largely due to operations undertaken in the name of piracy suppression. Finally, even his contemporaries noted that Charles Brooke's deployment of the Royal Navy is operation against pirates after becoming governor of Labuan in Borneo in 1846 was politically motivated. The only difference between the Diak boats that Brooke launched operation against and those of the Sarawak tribes under his protection was their political allegiance. The only extent detailed study of Anglo-Qing negotiation to suppress piracy in the mid-19th centuries, however, suggests that the Royal Navy did not want to be a global maritime police force, and in the China's case could not afford to be one. Maritime crime was not then an excuse for British imperial aggrandizement in this case, but was rather a problem which needed a multi-state solution to bring a legal order to the seas. This began by defining piracy and determining which jurisdiction was responsible for dealing with it. Throughout these, the term of maritime writing will be used instead of piracy to distinguish between the act of private robbery at sea and the legal category pirate, which, as we will see, was not so easily defined. So thank you for watching, and don't forget to like, comment, and subscribe.